everyone. So we're about to start our final panel of the day. This has just been an amazing day, and we're hoping that this final panel can be a wrap-up with a lot of questions and discussion about what's been happening throughout the day, questions that have come up for all of us, and what the next steps forward are. So we're actually not going to speak super long. We're going to present briefly, but we really want this to be able to be an opportunity to discuss everything that's happened today and to have a wrap-up. I also want to say, unfortunately, Judge Mozingo will not be joining us today. We still have the rest of our panelists, and also our acting director of the West Virginia Crime Lab is here and is joining us. That's Sherry Lemons, who's at the end. So I actually am really wowed that she's willing to come up and answer some of these questions and speak a little bit about our crime lab in our state. It's obviously vitally important. So our panelists today are Ms. Sherry Lemons, who is the acting director of our West Virginia Crime Lab. She's worked there for 15 years, initially as a bench analyst and now up to the acting director. She's also the quality assurance manager, which is obviously a national issue as well. She has a background particularly in DNA analysis. I will also be presenting. I don't think I ever said this. I'm Valina Beatty. I am an associate professor of law here at WVU. I also direct the West Virginia Innocence Project. Next we have Brandon Garrett, who is a professor at UVA Law School and is most well known in these circles for his book, Convicting the Innocent, Where Criminal Prosecutions Go Wrong. Excellent book, and in it he examines the first 250 DNA exonerations. Of course, that's not the entire universe of his work. He's also works in regulatory and administrative oversight, but in terms of innocence has looked a lot at testimony that's being provided. He was on the committee that created the National Academy of Sciences report identifying the culprit. So that's a report that came out in 2014 on eyewitness identifications. Next we have Associate Professor Jessica Sino, and she is also the Associate Dean for Academic Affairs at Georgia State Law School. She is both trained as a forensic analyst and is also a lawyer, obviously. She teaches on forensic evidence and forensic medicine, and she's testified in cases in Mississippi, leading to the reversal of at least one wrongful conviction. Interestingly, for right now, she's currently working on a podcast series, and it's coming out in May, and it's called Conviction. And she's working on that with journalist Liliana Segura, who spoke earlier today. Finally, Professor Jennifer Lauren is at the University of Texas Law School. She has written, actually, a piece I've assigned to my students, Remapping the Path Forward Toward a Systemic View of Forensic Science Reform and Oversight. As we've been able to discuss today, there's a lot of changes going on in Texas, and it's great to hear some of her perspective on what's been happening in that state around forensics. She also was the reporter for the ABA Criminal Justice Standards Task Force. In fact, I think she may still be. And she was previously on the ABA Texas assessment team of the death penalty. So without further ado, I think we're, am I beginning?
Maybe so.
Okay, I'll start.
Take it away, Valina.
And again, I'll just speak briefly. I think it's exciting that we're seeing movement and momentum right now away from relying solely on nonprofit Innocence Project organizations to incorporating post-conviction work into public defenders' offices, like in Ohio and Boston, and also into conviction integrity units. I believe there are now 24 conviction integrity units in prosecutors' offices, And one of them is with our own Northern District of West Virginia. U.S. Attorney Illenfeld is creating a conviction integrity unit as we speak. That, of course, is on the federal level. So that's a great response. However, the reality is, I think everyone knows, is that habeas is not efficient. I do this work. I love it. It takes years of litigation. So what can we do to make sure that accurate evidence is disclosed at trial and pre-trial? And I want to discuss a possible shift from towards pretrial disclosure even before a plea, so even in plea negotiations. And I want to discuss this because of the recent case that we've had in West Virginia, which really I think can be pivotal nationally, where our state Supreme Court has extended Brady and the need to turn over exculpatory evidence to the plea negotiation stage. Just last Friday, Judge Rakoff, who's been very vocal on forensic issues and is a federal district judge of the Southern District of New York, said that the plea bargaining system is unjust, excessive, and, quote, so totally untransparent, it's going to lead to some serious mistakes, end quote. Those mistakes have already been made. We know from the National Registry of Exonerations just last year, 40% of the people exonerated in 2015 took a guilty plea. That's where their conviction came from. So these are people who are innocent and took a guilty plea. And these pleas range from drug crimes to homicides, so very serious crimes. The plea system fails when innocent people are pleading guilty. And it falls on prosecutors for disclosure and also on defense attorneys for time and advising clients. The Supreme Court ruled in Missouri versus Fry that the defendant has a right to effective assistance of counsel at the plea stage. That the plea stage is not an adjunct to the criminal justice system, it is the criminal justice system, in their words. So what about the burden on prosecutors to disclose evidence before the pleas? Again, West Virginia seems to be at the forefront with this, with the case Buffy versus Ballard. Justice Workman, in her opinion, and then Justice Lochry, in his concurrence, both extended Brady to the plea negotiation stage of proceedings. I also haven't been able to see Al Carlin here today, but he's a phenomenal attorney in our state, and due to his very hard work, Joseph Buffy was able to take back the plea after the DNA evidence showed that he did not commit the crime, and that Joseph Buffy is now, as Ben pointed out, at least on house arrest for the time being. He is an extraordinary advocate and attorney. In Joseph Buffy's case, what's so remarkable about it is that he was given an exploding plea offer, so he had to decide by February 6th. He decides to take the plea, and then just days later, and he hasn't been sentenced yet, but he agrees to the plea. And just days later, the lab analyzes the DNA evidence and comes to the conclusion that Joseph Buffy is excluded. So it is not Joseph Buffy. And in fact, Buffy isn't sentenced until May 21st, so months later, and he has never received that evidence. So he goes to his sentencing, and the lab analyst knows that the evidence doesn't match him, but that evidence has not been disclosed to the defense. So he goes ahead and pleads guilty. The court ruled, and as we know, the Supreme Court has ruled impeachment evidence does not need to be turned over, but hasn't ruled on exculpatory evidence. And again, the West Virginia court ruled that we do need Brady disclosure in the plea negotiation stage. What's interesting is this argument that I think many of us come up against, and that we've talked about today, where is it only innocence if you have DNA evidence to show it? I mean, how else can we look at these very troubling convictions and wrongful convictions? And this is a case where there is DNA evidence pointing to someone else as the perpetrator in a single perpetrator crime. The victim has repeatedly said it's a single perpetrator. And yet, the DNA evidence wasn't enough in a habeas hearing for Mr. Buffy to get relief. The lower court said that the court wasn't sufficiently convinced that the evidence, quote, fully exculpates the petitioner as to the crimes to which he voluntarily entered a guilty plea, end quote. So the guilty plea was held against him. And also, the judge just was hypothesizing that, just because there's not the DNA evidence doesn't mean he wasn't standing there, doesn't mean he wasn't elsewhere in the house. I mean, it's just showing that even the DNA wasn't enough. And the Supreme Court in West Virginia said that that's not the standard that the judge should have been using. Again, the standard is materiality under Kiles versus Whitley. Doesn't require that disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal. That's not the standard. And I'll just briefly point out that the concurrence also says that we need to extend Brady and disclosure to evidence in the state's control that is favorable to the defendant, regardless of whether a plea agreement or a trial ensues. Okay, it doesn't have to be exonerative evidence. And he says, quote, there's simply no room in our judicial system for unethical evidentiary gamesmanship. I think that sums it up. There is a point that could be made that is this fraud on the court when you're not disclosing this under Rule 11F, West Virginia State Rules of Criminal Procedure and Federal Rules of Criminal Procedure. There needs to be an adequate factual basis to the plea. So is it fraud on the court not to disclose this information if you're the prosecutor? Also, it does make sense for the burden to be on the prosecution because these labs are most often within police jurisdiction, and prosecutors have access to this evidence being tested and the results. I also think this brings up related issues of if you are going to have the disclosure and you're waiting for the results from the lab, what about bail? How does this tie into bail reform and whether people are waiting for years to be able to get results, especially when our crime labs are overloaded? But I'm excited to see the direction that West Virginia is going and that potentially other states will follow as well. Thank you.
Good afternoon. Forgive me, this is extremely impromptu. Nobody hate me or anything. I am a scientist from the state crime lab, but I'm here to offer information about exactly what we do for the citizens and law enforcement of West Virginia. So I have, as she stated, I've been with the lab for close to 15 years. And I've risen through the ranks to the position that I hold now. So I see it from all angles, and now from a management standpoint, and working more now with the community, legal community, and just trying to improve the system as a whole, trying to make these improvements that we all see need to happen. But just a little background about what we have to offer here. We have one lab, and it's in South Charleston. It has less than 50 people that services the entire state, 1.8 million, and 800 law enforcement agencies. So while we are the West Virginia State Police Forensic Laboratory, we work for all law enforcement following the procedure of it being involved in a criminal investigation. We take the evidence and generate a report and are called to testify when needed. So we offer 8 disciplines. Odontology is not one of them, so just want to throw that out. We offer latent print analysis, DNA analysis, question documents, which is not as common anymore. We still have it. Drug analysis, toxicology, firearm and tool mark examination, and trace evidence. So those are the different areas that we offer services in. And I think that she hit on a good point. Thank you, Valina. There are so many issues that face this science. We've made remarkable progress, honestly, in our history of recognizing areas of improvement, recognizing foundation that needs to be laid, and some of them have had a head start. DNA is one of them. So we've made great strides, but there's a lot to work on, and so we recognize that. But I do want to say that for our lab in particular, we have met a lot of the requirements that are being discussed on a national level at this time: accreditation, certifications, things of that nature. Those are things that accreditation. We've been accredited for 21 years, so. A lot of that was precipitated by a name of an individual that you all will be familiar with, which was Fred Zane. He worked in our lab many, many years ago doing serology. We went through, we still face a lot of hurdles having that in our past, but we've made great improvements as a result of that. And so we have been accredited. We recently underwent international accreditation 2 years ago. So we are striving to maintain that accreditation, the highest level of accreditation you can get. We do have some sections that are certified, not all of them yet. That's a process in itself that I think was hit upon earlier, trying to figure out a way to handle that process, secure funding for that process, which is a constant battle that I'm facing in my role. But I do want to say that we are under the microscope for basically everything we do. And we recognize that, and we are trying our best to be as transparent as possible. The work we do is for anybody. The results are the results. We're called for the prosecution, and we're called for the defense. It just depends on what the scenario, what the hypothesis is, but that doesn't change the work that we do. But I do follow a lot of the advice. I've taken a lot of notes from my time here today on things that I'm learning from you, from your point of view, that we may not recognize because we are scientists. We do think a little bit differently, but I think we are a lot on the same page as treating the evidence as what it is, trying to go in without a preconceived notion. We do a lot of our testing separate. Question samples are brought in. Known samples are then tested. So we don't have that information. We're there to just make comparisons, to do the testing that we've been trained to do. But we're making strides, and I appreciate being able to be here. And I will take any questions at the end, I guess, if there are any. Thank you.
All right, I'm going to be cognizant of the time because we are your last barrier before you're allowed to leave. I also feel like I'm in moot court because the bailiff is right there. He's got my time clock. So first I want to say thanks to Valina and the Law Review students for putting on a phenomenal program. It's been a pleasure to be part of it and learn as we go throughout the day. So I'm going to talk about pretrial in terms of mostly reliability, a little bit about disclosure, and I'm going to come at it more from a litigator's perspective because I still do a fair amount of casework, and I tend to think about how to take these cases apart from that perspective. So traditionally, when I get involved in a case, it comes in two different forms. One is now I'll get hired as an expert witness on a case, and then I will usually get converted to the non-testifying expert because the judge refuses to admit me as an expert because I'm not certified in whatever field is being challenged, and instead I'm usually just talking about the shortcomings or the weaknesses of forensic science. The second part is I may get called in more from a strategy component of mounting a Daubert challenge, mounting a Frye challenge, and how to go about that, and assembling the evidence and looking at it from that direction. And sometimes, mostly depending on the lawyer, I will actually end up drafting and putting together the Daubert motion for them. So, from the pretrial standpoint, what do you do when this type of evidence is dumped in your lap or on your desk? And I had lunch last week with a prosecutor, and sometimes prosecutors will talk to me. But he was lamenting just how awful the CSI effect is, and it's just letting people out left and right, and they cannot get a conviction. And I tried to reason with him that the converse is actually true, that when forensic science is offered in these cases, people tend to believe it's gospel, regardless of any holes that you're able to poke into it. But he wouldn't listen to me. So it is an uphill battle, in my view, from the defense standpoint especially. And generally, my first stop where I try to figure out how to challenge the evidence is looking at reliability. And I look at reliability as a three-legged stool. One is, was this methodology, or is this methodology reliable? The second one is, was the methodology reliably applied in this particular case? And then the third one is this expert actually a reliable expert? Is this expert qualified, in other words? So, theoretically, if you knock one of those out, one might say that the evidence should be inadmissible. Practically speaking, of course, all of the veteran lawyers will recognize this phrase that, no, that goes toward the weight and not the admissibility of the evidence. So, it's really this obstacle course that you have to get through when you're trying to challenge this evidence in the pretrial setting. So, looking at, is this methodology reliable? Well, I'm going to come right out and I'm going to agree with Megan and Simon and say, yeah, things like the ACE-V method is not science. It's just not. But, it's an art. So when I try to take apart the evidence from the methodology standpoint, the first place I stop is the NAS report. And all defense attorneys should know exactly what the NAS report says. What I find astounding sometimes is I get invited to go in and train federal public defenders' offices, local public defenders' offices on how to do these types of challenges, and they have never heard of the NAS report. And that thing is, 7 years old now? It came out in 2009. And so, so that can be just a challenge in and of itself in terms of working with the attorneys. And then, even if you are able to make some inroads on the methodology, I'm going to kind of use a phrase and betray my Kansas upbringing, but it's like the Wizard of Oz. You can pull back the curtain, but the judge is going to keep that blindfold on, right? The judge is going to essentially sit back and say, well, I've been letting this evidence in for the last 20 years that I've been on the bench. I'm not going to stop doing that right now. So then I move on to, well, is it reliably applied in this case? And that's where pretrial discovery is critically important. You need the bench notes. You need what are the standard operating procedures for that office. You need the chain of custody. And then once you get that, you have to look at it from the standpoint of, well, what's the existing scientific literature out there? They showed the website with the National Commission of Forensic Science. They've actually got reports. There are reports from NIST. There's the NIJ report. You can collect all of this information and start looking at what are the best practices supposed to be versus what were the practices that were followed in that particular case. And then once I do that, I also look at how the verification was performed. The last panel talked about, do they know the conclusion going into it? And resoundingly, the answer is yes. I can't tell you how many labs I see where on the verification part of it, the verifier knows the conclusion before they ever look at the evidence. That's pretty textbook procedure. And then finally, I look at, well, is this expert qualified to actually be doing this comparison? And you may think that that is sort of a throwaway, but I'll tell you, when we were doing the Corey May case in Mississippi, Radley Balco called up our firm and said, hey, Stephen Hain, he's not actually qualified to perform autopsies. He's not a board-certified forensic pathologist. And so, you should always go through the resume of the person who is presenting the evidence. Because even if they say they're certified, they may not be. And then if you go through and actually look at, for example, the code of conduct that the certifying organization has, they may not be following that code of conduct. And I've had that come up in numerous cases. Now, the reality, of course, of all of this is even if you do your best efforts on putting together a great Daubert challenge, it's still going to come in. Or a Frye challenge, it's still coming in a lot of these cases. But what you're doing is you are laying the foundation for the record. You have to preserve the record in these cases, because when you get to the post-conviction stage, if it is not there, there's no way to go back and prove that. You can't recreate the record. I can tell you, as a lawyer who, sometimes I'm in the witness chair, which is a totally disconcerting place to be when I'm much more comfortable cross-examining. But sitting in the witness chair, there is definitely a problem sometimes with the quality of defense counsel. And I've had to object for myself in court, which the judge laughed at, but actually let it go. I've also had to, from the witness stand, remind the attorney that he needs to proffer my testimony if it was going to get excluded. And so my last point that I'm going to make, because I'm completely out of time, and this I'm going to aim this mostly at the law students in the audience, is that as lawyers, our duty runs to the client, it runs to the court, and it runs to our profession. And part of our duty is that we need to study the science, or the lack thereof, in these cases. Because if you don't, and you just accept what the expert says, whether it's your expert or the opposing expert, you are not doing the duty that you have promised to your client. And so my advice to you is to be curious, ask questions, study the science, and don't give up.
It's late in the day. This is absolutely related to what we were just talking about. I thought I'd start with a lawyer joke. And it's a lawyer goes to the client and says, I have good news and bad news. Your DNA matches the crime scene. And the client says, well, that must be the bad news. What's the good news? And the lawyer says, your cholesterol is down to 140. Anyway, so I'm sure there are like 1,000 variations of that joke, and other sort of lawyers and forensics jokes, mostly probably focusing on DNA. But who knows, maybe there were lawyer fingerprint jokes 20 years ago more than there are now. And what I wanted to just briefly talk about for a couple minutes, it would be nice to have more Q&A. It's the end of the day. For this symposium issue, I have two exploratory studies that I have done with my colleague Greg Mitchell, who's a psychologist and a law professor along with me. He's one of my colleagues at UVA, focusing on what lawyers think about forensics as compared to jurors, since what the lawyer says to a client in a conversation, something like that, may matter a lot more than what happens in a courtroom, given how many cases plead out. And so it really does matter whether lawyers understand the strengths and limitations of forensic evidence. And so we did this exploratory study. We learned just how challenging it is to get lawyers to participate in studies. Lawyers like to consume expert evidence and rely on statistics, but lawyers are busy and they really hate to take studies. We all have survey fatigue. We surveyed 264 lawyers. We sent out the survey to every imaginable defense organization, and that's all we got. So that's why this is exploratory. We surveyed a similar number of jurors for a reason I'll explain in a minute. Almost all of the lawyers who took our survey were defense lawyers and not prosecutors. So if you have any suggestions, do we have to, give $10 Starbucks certificates to get prosecutors to take a survey, $20, certificates to something else? I don't know. How do we get prosecutors to take this survey? We'll have to find out. So what we only asked some very simple questions. It didn't take much time for these lawyers to take the survey. We asked lawyers how reliable they thought fingerprint evidence was and DNA evidence, and just a couple of questions. We also asked them what they think about jurors. How reliable do you think the jury would find such evidence? The defense lawyers were quite skeptical of fingerprint evidence. It was sort of a nice bell curve. Most of them kind of thought fingerprint evidence is kind of reliable. Some thought it was really reliable. Some thought not so reliable at all. But when you ask them, well, what do the jurors think? They're like, oh, well, almost all jurors think it's completely infallible, or at least extremely strong evidence. 55% of the lawyers said that jurors would find fingerprint evidence to be infallible. Lawyers, when asked about DNA testing, they were actually probably over-skeptical of DNA evidence. They said, well, about 83% of them said DNA evidence is very strong. And you're thinking, well, so there's like a significant chunk, not a quarter, but a little bit less of these lawyers, mostly defense lawyers, that are somewhat skeptical of DNA evidence. And obviously there can be errors in DNA cases, and you should all read Aaron Murphy's book if you haven't. But still, so maybe over-skeptical of DNA evidence. We then asked, actual lay people using Amazon MTurk, what they thought of fingerprint evidence. And what was really interesting about that is it so totally corresponded to what the defense lawyers thought jurors would say. They universally thought that fingerprint evidence was awesome, amazing, infallible. Greg Mitchell and I had done prior survey work looking at, well, just asking about jurors about, or jury-eligible adults about baseline reliability of fingerprints, and 95 to 97% said it was unique. And what we found then is doing experiments on those lay people that it was very hard to dislodge jurors' priors, that this is just extremely strong evidence, even if you explain the methods more and give varying degrees of certainty and conclusions. But what really surprised us in this study was that when we asked these lay people, who are far more demographically diverse actually than the lawyers, maybe like you'd expect, what they thought of DNA evidence, actually fewer thought that DNA evidence was unique than thought fingerprint evidence was unique. Their priors are actually stronger in some respects on fingerprints than DNA. Now that said, there are very strong responses on DNA too, but we actually had 92% saying DNA was unique and 95% saying fingerprints were unique. Now we didn't provide detailed explanations of how one might define the word unique, and in fact, twins have the same DNA. It's possible for someone to share a DNA profile. There are probabilities associated with these things. I doubt that many of them were thinking in those terms. Finally, I'll just say that so very few prosecutors took this survey, so anything we have is to be taken with lots of grains of salt. But it was interesting. It sort of confirmed a CSI effect story that the prosecutors were very divided in terms of how they thought jurors would be weighing fingerprint evidence. They thought that a lot of jurors, about half of them, would be quite skeptical of fingerprint evidence. So prosecutors clearly at least the few that took this, thought that jurors would be quite skeptical of even fingerprint evidence, when in fact what we found was the reverse CSI problem, that jurors thought fingerprint evidence was even better than DNA. And so we'd like to survey many more prosecutors. This was exploratory, but it was an interesting, at least initial look at how practicing lawyers, and we had nice information about how long they had been in practice and how many trials they had done, how practicing lawyers look at this stuff. We also found, by the way, that a far higher percentage of women than men believe that fingerprints were unique. I don't know what that means. Anyway, I'll stop there. Thank you all so much.
All right, I'm going to try to, I'm a pretty unsophisticated PowerPoint user, but we're going to try to give it a whirl. All right. All right, so we've kind of gone in the sequential order of the life cycle of a case, and so I'm playing cleanup, talking about the post-conviction context. And what I want to talk about in particular is the difficulty, what I'm going to call the structural barriers, to change scientific understanding, being able to be sort of reincorporated into a case, right, after the closure of the case in order to achieve an accurate outcome when an error has been made. Very little of what I am going to say is going to be completely new. I'm going to do my best to sort of repackage and resynthesize in a sense, because so many of the really fascinating presentations that have come earlier today have touched on so many of these issues. But the sort of bottom line sense or view on this that I want to try to impart is that I think it's so important to take a systemic view of the problem. And that is to say, that in terms of assessing and overcoming some of the very serious barriers to reincorporating changed scientific understanding into the criminal justice system, focusing on the science alone is not going to fix the problem. Focusing on legal doctrine alone is not going to fix the problem. The attention to structural barriers to science filtering back into the system is critical. So I just want to start by reminding you all of something that a number of presenters have already touched on, which is that criminal law has a science lag, right? Science at time one is going to play a role in conviction, and the scientific conclusion at time one changes, right? That could be, and this is the picture up top is the famous or infamous analyst in Boston, Annie Dukin, right, who was actually convicted of fraud, right, in the course of on criminal charges of fraud for her dry labbing and other illegal practices in the Boston crime lab, sentenced to 5 years in prison. So it could be that there's a scientific change, right, because of misconduct. Far more frequently, right, it could be that either the scientific conclusion at time one was erroneous but not fraudulent, right, or it could be, as we discussed in the context of the last talk, that the science at T1 was accurate at T1, right, but the scientific opinion has evolved, right. The bottom line here is that at time two, there are going to be significant impediments to updating the application of science to the case. And what I want you to think about is sort of a stream, right? The end of the stream is litigating the science anew. There are, at that end of the stream, right, barriers. There are downstream barriers to litigating the science anew. And I'm not going to go through these because, for the most part, I think actually Syed's presentation in particular touched on them, right? The sort of role that finality plays in the criminal justice system, right? And the many barriers, doctrinal barriers, to obtaining post-conviction relief that, I will make this point, sort of affect changed science in a special way. In other words, it's always hard to get back into court and say someone made a mistake, but actually, and perhaps ironically, right, doing so on the basis of changed science can be even harder than other types of errors that one would point to in the conviction. These are typically changed understandings that become understood quite gradually, right? The point that Syed was making, and that Radley was breaking. When is the tipping point? When do we know that we have to get into court because the time is ticking? Procedural default is a huge issue in these cases, and there's a problem of sort of poor fit between changed scientific conclusions and the most typical constitutional claims that individuals would make. I do want to say as well, though, the fixes here are in some sense quite straightforward, in that although it's perhaps not politically popular, right, and we haven't seen a wave of this, Texas sort of stands alone in the junk science writ that it passed. One can sort of fix the doctrine, right? At least we know how to do that, right? But the point that I want to make here is that even if we fixed the doctrine, if we changed those downstream barriers, there would be significant upstream barriers to getting a changed scientific understanding back into the process. And that's what I want to focus on. What would need to happen to do that? Well, we need to generate the changed understanding, right? And we need to get the change into the adversary system. And the point that I want to make is that all of the gatekeepers to that changed understanding come in are structurally and institutionally incentivized to be barriers rather than conduits to that. And I'll just sort of quickly run through this, right? The role of the scientific community is an important one here. It's also the one that's probably been the most discussed in terms of changing what the scientific community can do to try to produce better research and update understanding, right? To try to revisit cases within laboratories or within disciplines. As currently structured, I think it's fair to say it's still the case that there is insufficient research, foundational research in the scientific community and in the forensic science community. And to the extent it's there, it's quite low visibility. It's difficult to find. There are unclear disclosure norms still within the forensic science community, which is quite important, right? There still is not a sort of consensus norm on how the forensic science community should react if there is changed understanding. And for reasons discussed earlier, there are very serious sort of personal, professional, cognitive barriers to forensic scientists themselves. Oh my gosh, I am way close to being out of time. Okay, to forensic scientists themselves pushing change in their field. But even if the scientific community were sort of generating a better level of feedback, right, about error or evolving science within the community, prosecutors and defense counsel remain themselves in the post-conviction context poorly situated to be good conduits for this information. Prosecutors tend to be sort of the gatekeepers for revealed changed scientific understanding. They sort of know about more of the cases, and our criminal justice system tends to see prosecutors still as kind of pushing the ball. But in the post-conviction context, even more than in the pretrial context, there are unclear disclosure norms for prosecutors. There are serious cognitive and professional sort of incentives to view arguably marginally changed science as unimportant or immaterial in cases. There are serious resource issues here, right? What's a prosecutor to do? I'm out of time, but I'm going to take a little bit more. What's a prosecutor to do in terms of mobilizing the resources of their office to deal with serious post-conviction review if they don't already have those resources in place? The same arguments in terms of resources could be made in terms of defense counsel, right? Not only does defense counsel have a limited post-conviction presence in cases because they're not constitutionally mandated to be there, but defense counsel has way insufficient resources, right, to be revisiting, relitigating old cases as they're trying to handle the cases that they have. What's the bottom line? We need some intervention, some structural intervention to break the upstream barriers to change science entering our system of adjudication and reviewing it post-conviction. And what I want to highlight in particular is the role that sort of what I'm calling trusted brokers can play here. And this is where I think the example of the Texas Forensic Science Commission that Sandy raised earlier is such an important example, the role that it has to play here. I want to highlight, she pointed to the systems chart, process chart that the TFSC created in order to handle the issue of changed understanding of DNA mixture calculation. And the reason I want to highlight this is the point to be made is not just it's complicated, right? Because it is, and they came up with a way of systematizing it. But what you see on this chart is the TFSC, together with all the stakeholders in the system, has engineered ways to overcome those structural barriers, right? It becomes the conduit for notification. It incentivizes further interrogation of the scientific methods. It provides prosecutors and defense attorneys with a forum for working out the implications in a particular case, even before it goes into the system. And so there are features of the Forensic Science Commission that accomplish overcoming those barriers. I'd be happy to talk more in the Q&A about other possibilities for doing this structurally. But the bottom line, to my mind, is if we're not thinking systemically and structurally about how to address science in the post-conviction context, we're missing the boat. Thanks.
Great. Well, in terms of questions among our panelists, I'll start with one, which is, Professor Moran brought up the low amount or low visibility of non-case research. And I think a number of times it's been brought up today, this divide between forensic scientists who are doing these experiments and furthering the science itself and analysts who are doing the work in the labs for these cases. And I'm wondering if anyone has suggestions for how to overcome that divide, if that is a strong divide, or whether that's just a natural progression that will continue to develop to have more people getting research grants and being able to do the impartial research. And especially Director Lemons.
I think that improvement has been made in that area, especially recently. A lot of the forensic programs that are out there now are either in the process of becoming accredited or already accredited. And part of that is cooperation with a public laboratory to place students and interns to do some work, to do some cooperative partnership research projects. We rely heavily on that. We need that because our role is to do the casework. We do not have staffing or manpower to research all the new methods that are out there, all the latest developments that are coming about of, okay, we need to look further into this. This is being questioned. That's can't be our job as a bench scientist who's got caseload requirements and quotas. So we rely heavily on that. So I strongly support that because academia, that's their strength. They're research oriented. We are not so much in that aspect. So.
Could I ask a question?
Yeah.
Great. Thinking about pretrial disclosure, I guess Felina and Jessica spoke to it most directly, but I'm really curious to hear everyone's views on this, and again, especially sort of your view on how this implicates the work of labs. And one reason I ask this is because, frankly, so the ABA task force that I'm on is on discovery standards. And so a big question is, right, what do you do about pretrial discovery as a general matter, pre-plea discovery, particularly of forensic evidence? And it seems like everyone can agree that it's crucially important for defense counsel to have maximum amount of sort of raw material, not the reports, maximum amount of raw material in order to get under the hood of the ultimate conclusion that's reached. And this is not just in DNA, right? And this is why it's so problematic. You know, good defense counsel is going to want to get under the hood of, you know, what happened in that intoxilizer, right? And so at the end of the day, we end up talking about this being important in the very, very high volume run-of-the-mill cases as well as in the big ones, right? So you get what I'm going with, I'm going with this. There's a huge resource concern, right? There's a resource concern when you talk about generating all this, which currently isn't being done across the board, though it should be. There's an even greater resource concern when we think about accelerating the generation of all of this, say to the pre-plea stage, especially in less serious cases where there's going to be earlier pleas. Solve the problem for me. What do we do? Esteemed colleagues who've thought about this also.
You bring fewer criminal cases so you can do them right?
That's. I proposed that in one draft of the standards, and I'm not sure it's going to happen.
I'll say from my standpoint, I surely don't want to monopolize, but it's interesting when speaking of data that is generated that may not render the conclusion that meets one side versus the other. That, and it may sound crazy to you all, but that is incomprehensible to me as running an accredited laboratory. Every one of our analysts knows that all the data in a case is included in the case file, regardless of what it is. If a run fails, it's included in the case file. There's no reason for it not to be. All of that goes into the opinion that's rendered. So the example given by, I believe, Dr. Jackson earlier with confirming of drugs, all of those runs are in there. We have a policy very similar to what he discussed. So that's all available upon discovery. It's been discussed that all of the case files should be handed over with the reports. And that's not an objection that we have. It's simply a manpower issue. I do discoveries regularly. Every week I get discovery requests from prosecution, defense, court-ordered mutual agreement. And we obviously will comply with those and give whatever's needed, but it just takes so much time to get all that information. And I wonder, I've asked some of the parties who request it later on down the road, a lot of the times it's not even looked at. And so then it discourages us from wanting to give that with every case. Because even when they get jumped through hoops of giving us documentation requesting it, they don't look at it. So it is a resource issue, not a lack of wanting to offer it, because we don't really mind to do that. But it's interesting because I know we talk about pretrial discussions, meeting with, the attorneys on the case. That rarely happens. Rarely happens. Most of the time we get a call that we need to be there in an hour. They've not looked at the case or the work, and they want us to fax a copy of the report before we leave to come and testify. So not always, but they're playing catch up just like we are. It's a resource issue, and we're all trying to run around and do the best we can with what we have. So.
Well, and I think part of it too is there is, on both sides, on the side of the lawyer and on the side of the lab, there is sort of this institutional norm of, well, this is the way we've always done things, so we're just going to continue to do it this way. I can't tell you the countless case files I've seen where all I get is a piece of paper that says, latent print number 33 has been identified to John Smith, and then I ask for the bench notes. Nope, didn't take them. Or I'll ask for any other records that relate to that conclusion, and it's just there absolutely aren't any. And I think it is a long process in shifting the paradigm of what is expected, what is the practice that you are supposed to do as a good examiner. And then that translates down to the attorneys too, because the biggest complaint that lab examiners have is just that. You called me an hour before I'm supposed to testify, and now you want me to talk to you about what I've been doing in the lab? And so I think there's just this huge, we have to get to a point where we learn to cooperate with each other as opposed to just constantly being, at odds with each other.
Great. Can we pass around the microphone? I know Russ had a question.
Thank you. My question is for Jennifer, I think first, but then to everybody here. I'm curious as to your thoughts. I mean, Jennifer, you were talking about post-conviction review, and one of my primary concerns are the sort of the bundles of cases where the science has failed or the evidence is weak. But there's no real mechanism available to go back and look at these cases again, right? And so. Do you have in an ideal world, how would you handle that problem? I mean, would you rely on innocence commissions or the if the FBI or law enforcement, some agency decides to go ahead and do a re-review of some class of cases, or is there some better way to systematize the review process? And who should be doing it? I mean, should it be the courts? Should it be the law enforcement? Should it be sort of external commissions or innocence projects?
Yeah. So I'll take a crack, and then I'll be really interested to hear others' thoughts on this. I don't want to cheerlead too blindly or strongly the closed-eyed cheerleader. For like the Texas model. But I do want to say a little bit more about why I think that the particular way the Texas Forensic Science Commission as a body outside the adjudicatory system approaches this has worked very well. And here are some of the ingredients of it. One, it's a body that is outside the adversary system, which has a dedicated mission to advancing the reliability of forensic science, right? That's it, and its mission is not, more broadly, finding error in the criminal justice system. It's not exonerating innocent people, right? It's certainly not enhancing the state's verdicts or enhancing the defense case. It is protecting the integrity of forensic science. And I think its membership is almost entirely scientific in terms of expertise, right? With just sort of token representation, right, and even representation from the bar. And those two features, I think, just as a starting point, make it particularly well suited to be conducting these kinds of reviews when the need arises, because it's really become, I think for these reasons, a trusted broker in Texas. There is a very, I think Sandy used the term earlier, buy-in. And I would go farther and say sort of trust and confidence, like for the most part, and I think it's a fragile one, honestly. I think they could abuse it, right? But trust and confidence from the legislature, from defense lawyers, from prosecutors. It's fascinating. If you go to the Texas District and County Attorneys Association website, they sort of amplify what the Texas Forensic Science Commission produces in terms of notification procedures for defendants for DNA cases. Here's the DNA case review process that TFSC is following. Here are the guidelines TFSC has issued for what prosecutors should do in these cases. And that the TDCAA, which is a, well, you can just guess the kind of organization it is. I mean, it's closely aligned with prosecutors. It's not a kind of progressive, we're going to reform the prosecutorial world organization. It, in fact, sort of politically within Texas, keeps itself very closely aligned with the local county prosecutors. But it has engaged deeply with, and sort of validates the Forensic Science Commission process, which then obviously is perceived by the local prosecutors as signaling that they should fall in line as well. So I guess the general answer I'd give is I think the right approach is someone outside at least the state and the sort of local adversary process. And I think the best design is to think hard about how that entity can be positioned as an advancer of science rather than a finder of mistakes. I'm sorry, just let me make one last point about this. The rhetoric that the head of the Forensic Science Commission, well, their general counsel in particular, has really emphasized is quite resonant with the kind of Sentinel events review literature that some folks might be familiar with, this idea that the goal of a process should be to bring stakeholders together and find mistakes and not to place blame. And there could be a very valuable conversation about whether there are more avenues in which, or ways in which blame can be placed. But I think in this process, in making sure that people are willing to get together and review cases, that the lab is willing to come forward, that the prosecutors are willing to notify defendants, that everyone's willing to come to the table, it has been very effective that the FSC has completely taken off the table the possibility that it is aiming to sort of identify blameworthy behavior in the scope of this.
I'd just add briefly, I think this shift with the FBI of more transparency and self-evaluation, which has led to, they had reviewed their own work in, the mid-2000s, but that was never disclosed to defendants. So this recent, re-looking at these hair cases and now re-examining themselves in other fields, I think that transparency is helpful for those of us who see a case, we're like, oh, is there something here? And someone, again, outside of the system to a certain extent, who has that scientific knowledge and then says, yes, there is an issue, I think that's really helpful for bringing these to light and bringing claims that are possible. Bradley.
I think this is probably for Jessica or Valina, but if anybody else was to chime in. This comes from a couple conversations I had earlier today, but from both sort of an ethical standpoint and a strategic standpoint for criminal defense attorneys in these cases, let's say you find out the prosecution is going to put on, bite mark evidence or hair fiber evidence or some other sort of junk science against your client. You believe this is junk science. Like ethically, can you put on can you find your own bite mark expert to counter the prosecution? Do you just challenge the validity of the entire field? I mean, I've read appellate court opinions where the appeals court cited the fact that the defendant put on their own expert as a way of sort of disqualifying them from making some sort of a claim against the legitimacy of the entire field in general. That the very fact that you put on your own expert means that you must believe in this field in some that this is a plausible form of analysis. So I guess I'm interested just from a strategic standpoint, and then also from an ethical standpoint, like how that breaks down.
So there are two ways to approach the type of expert that I would use on the defense for this. One would be, are we going after the accuracy of the conclusion, or are we going after the science as a whole? Well, and that's the question. What I've done in the cases I've been involved in the last 2 or 3 years is to find a expert who fits both of those. So a certified, for example, latent print examiner who has since sort of had their come to Jesus moment, and they understand the shortcomings of the science, and they can also evaluate the accuracy of the identification. I don't know, I haven't done a bite mark case to know if most of the bite mark folks are still drinking the Kool-Aid on that one. But that would be my first strategy. I think, from an ethical standpoint, what we do is we have to give the client the best representation possible. So if it makes more sense strategically to have that expert testify about the accuracy, and they don't even touch on the underlying science because there's, for some reason, that you deem that to be the better way to go, you might have to, but I would say there's just so few cases anymore where you're going to only, in that isolated silo, go after the accuracy and leave the methodology alone. I always try to couple the two together.
I would simply add, I think you see this, SBS is a good thing to look at because it does continue to be, I wouldn't say so, but others would say it continues to be a live debate. So there is an argument that could be made that you simply cross the witnesses on the other side, the experts on the other side, and that you just hammer after them. I think with a complex scientific cases like that, you really do need to bring in someone on your own to explain these rather than just to challenge, but that is a strategy, to just go hard against the other side.
Director Lemons, I'm curious to know if you and your colleagues as lab directors have considered, in light of what's going on with the FBI nationally in several states, about doing hair comparison audits of prior cases.
Absolutely. We just actually had a brief meeting at the lab about how we want to tackle that. We know exactly who was trained during that period. The question becomes, how do you even begin to go back over 35, 40 years of hair cases? And what we're going to plan to do is to try and hire someone to just work on that project. But we do have a plan of how we're going to attack it, absolutely. We're lucky, or he doesn't seem to feel so lucky, that we still have somebody there who was trained during that period. So when I brought him that inquiry, he was like, oh, no. I mean, it's been kind of rumbling for a while now, but we absolutely plan to address it. It's just one of those things where as time evolves and things evolve, you have to go back and reevaluate. Forensics is a relatively new field, and so we're constantly going to be going back and double checking, what did we do? What opinion did we render? Was it accurate at the time? And knowing now, maybe not so much now, how do we plan to handle it? Absolutely, yeah.
Contact us at the IP. We'll be very happy to consult.
Okay.
I was going to say, Chris will probably tell you, some of us at UVA are starting to work with labs as part of this CSAFE group that others have talked about today. And one of the first things we say when we were talking about doing an audit of old cases like that is that you probably don't have a spreadsheet of cases from the 1980s, right? There probably was very, only paper case management systems to identify, here's a list of all the hair cases that were, and so you really have to rely on the bar because, even searching through Westlaw, you have to rely on on reaching out to lawyers to say, if you please try to remember what are the old cases that you worked on and that went to trial, and even if you identify cases within the lab based on notes, well, was that a case where someone testified at trial, and then you don't have the resources to go to county courthouses to pull
No.
the transcripts, but the bar can help with that.
Absolutely, and that's what we plan, to a multi-team approach to first track down in the basement of the lab the old file cabinets that contain files from 30 years ago, and going through and seeing from those where were positive associations made, and from those where was a testimony rendered. It is going to be a multi-system approach that's going to absolutely require some help on that end. Yeah.
And that's also where law students can come in helpful, definitely, in the West Virginia Innocence Project.
Today we've heard people talking about, how judges are poor gatekeepers of science, and also the importance of independence of labs. And something that didn't really get talked about, but kind of relates to what Radley was saying, is that, at least from my perspective as a federal habeas counsel litigating state convictions, I see the fact that judges in my state are elected and then also have the power to appoint counsel in indigent cases, which is all of them, almost, all the ones that come to me anyway, as creating this really perverse incentive of the lawyers who are relying on future appointments for their occupation and for their income, not wanting to rock the boat, not wanting to request the expert funds to require all of this pretrial discovery, preserve all the records, make all the Daubert and Frye motions, and ultimately the judge wanting to have a strong record of convictions and not, be the one who let the murderer get off. And so, I think that's a structural problem in the system, but it creates, or it fails to create the incentives that we need to really bring out through advocacy, the flaws potentially in the forensics that are going into these cases. And so I didn't hear anybody talk about that today, and I just wondered if that's an area that anybody is working on, sort of looking into reforms, or even just, kind of pointing out how these problems can lead to, or fail to expose the problems that we are more specifically talking about in the science.
Sandra Day O'Connor, she's the one,
Well, yeah.
she's leading the charge to, right?
Yeah, let me add to that too, as a state habeas lawyer. The judges who are reviewing the habeases are often, the judges who are reviewing these habeases are often the same judges who were sitting on the at the trial. Which
Or
becomes
the
very
prosecutor.
difficult. It's the same, it's often the same prosecutor, it's the same judge, and, I'm being appointed. It's funny, now that you mention that, I'm not getting any cases out of a certain county. Now that I think about that, I might have to call. So that's certainly something that, I feel like there's this inherent bias built into the system where our clients are not getting a fresh review often of their cases because the judge, you can argue that this information should not have been put before the jury, but you know what? The judge has already heard it, and he's not going to forget it, or she's not going to forget it. So maybe if you could address that as well.
Well, I had a thought to share more maybe on the defense appointment question, but maybe I'll also be able to speak to the other one. So I would go back to and climb back on my, it's the system horse. Because I do think it's incredibly important to ask the question, right? And especially, it takes a lot of money, and we're not very good at fixing things when they're already way broke down at the end, right? So what's generating, right, the error-creating atmosphere in the beginning? And I think there's no question that problems with particularly indigent defense in the United States are a big player here. How are defendants appointed? How is defense counsel appointed? What are the pathways to resources for them? I have a couple of thoughts on this. And actually here again, I'm going to do a plug for one of, I think, the only Texas entity that Sandy didn't include in her earlier account, which is the Texas Indigent Defense Commission. And a number of states have indigent defense commissions that play various kinds of roles. Some are weak, some are strong, some sort of oversee the work of defense counsel. Others, and this is the direction I'm going to go, do more with thinking about what are the best sort of forms of delivery of defense services. And that's perhaps less a relevant question in states that have strong sort of state public defender systems, but in a number of states, including my own, yours, right, that's not the norm. And there's been a lot of effort, in particular actually in my home county of Travis County, where Austin is. People might not think of Austin, Texas as a particular site within Texas that is likely to have a particularly dysfunctional system of appointing indigent defense counsel, but indeed it does, because although the lawyers are pretty good in town, the judges are appointing all of them, right? So the solution was Austin received a grant from the Texas Indigent Defense Commission to create an entity for a managed counsel appointment system, right? So take it out of the judges. And just that small change, right, can make an enormous difference that cascades, right? It affects the quality of the lawyer. It affects, or randomizes anyway, the quality of the lawyer, right? It decreases the sort of codependency between lawyers and judges. But I do think that as a general matter, the question of sort of defense counsel access to resources to deal with forensic science on the front end is hugely important. And another solution or another approach that I would trumpet here is thinking about ways to leverage transmission of information about forensic science to the very fragmented world of indigent defense, right? We tend to think about public defender offices, but that doesn't really describe the reality in a lot of places in the country. It's a lot of solo practitioners sitting around not getting daily updates from their supervisor about the latest trends in SBS. So you have places like North Carolina that have added sort of forensic resource counsel as a position in their state indigent defense organization. And the job of that person is to be the statewide expert, right, on forensic science for all the public defender offices, for the solo practitioners, whatever, who don't have their own staff on board. PDS in DC has sort of taken this on somewhat as a mission as well. But thinking about how we can sort of leverage very, very limited resources for trial-level defense counsel is hugely important.
I'll briefly say I love that idea of the Forensic Resource Council. I hadn't heard of that, and we just opened up a new public defender office in our state, but it goes back to that push and pull between court-appointed versus having a public defender's office, and that can often just be political, and whether the court-appointed bar has enough political power or is, effective enough to keep out a public defender's office. Question in the back. Oh, were you going to say something?
Hi, I just wanted to take this opportunity of being in a room full of more lawyers. As a forensic scientist, we're always being pushed to do better science, and you all are being asked to understand science better. In the opposite part of it, how can we as forensic scientists help you understand what we're doing better so that it's more understandable and more transparent? I would take from the panel or from anyone in the audience that might have a suggestion.
I'll go, you start.
So I think fundamentally it boils down to understanding that we don't actually speak the same language, and then getting past that hurdle is that there has to be an early dialogue between forensic scientists and the lawyers. And I know, for example, I do a lot of work with what was formerly the Army Crime Lab. They're now the Department of Defense Crime Lab. And, their motto is, we don't care if you represent the defendant or you represent the prosecution. We talk to everybody. You call us, make an appointment. We will sit down with you for however long it takes. And that's, I think, the culture that other crime labs could really benefit from. Of we don't make the distinction of which lawyer is calling. They want to learn more about the science, and making that time to sit down with them, as opposed to, I've dealt with other labs where that has not been the case, where the defense counsel calls and they are, we work for the state type of mentality. And I think, too, again, that also means that for lawyers, you can't just expect to say, you're testifying on Tuesday, can I meet with you Monday? And so there has to be a cultural shift there as well. How we get there, I think it takes just gradually just more communication between the labs and the lawyers to say, hey, you know what? Wasn't okay for you to say you need to meet with me at the last minute. I'll do it this one time, but next time could you maybe call me earlier? And I've had lab examiners tell me that that has been quite effective for them in dealing with counsel who they see frequently.
I also think an important shift that can be pushed, again, by sort of some external actor, and here we've seen some of this in Texas and in other places, is creating more sites for analysts and those within the forensic science community and lawyers to interact and share information outside the context of the case, right? Which is about sort of learning together what the distinct and mutual needs are in litigation. It's spaces for lawyers learning more about science. It's spaces for developing a shared sense of goal, right? But there aren't enough of those spaces or opportunities or moments. Certainly cases don't create them, and so there needs to be, right, some impetus for creating them.
Yeah, we need almost like shared continuing education courses.
Right, and that's something that we've moved to in Texas.
We have something we've recently initiated a newsletter that we disseminate throughout the state to law enforcement, all officers of the court, in which we put a piece in there that said we have a lab roadshow, and we are willing to come and speak to groups to explain what can we provide, what services what are our limitations. We actually had our first response with Kanawha County Public Defender's Office. 30 of them are interested, and so we've set up a training for them that's going to take 1 day a week over the course of 4 weeks. Every discipline in the lab is going to come and speak to them on what we have to offer. So I think we've not done that in the past. We're really trying to think outside the box. I think you're right. We've always just kind of gone down our own little path of this is our job, this is what we do, but we cannot think like that anymore. So that's one example of where we're trying to improve.
This is just a small point, but as you were saying about the military system, Jessica, the prosecution and defense alternate.
Right.
So that really
makes
is
a
a
huge
different
difference.
culture, and I think that does have an impact on the dialogue. In other words, for people who don't know, you work as a defense attorney in the military, and then a few months later, you're on the prosecution side. The prosecutors are on the defense side.
Well, it looks like we're about out of time, or that we've run over, but it looks like there's also a forensic question here.
One quick question.
I just was going to comment.
Great.
Just to follow up on what you were just talking about, I recently brought up the fact that I taught a basic crime scene class in Savannah during one of our continuing education programs, and I opened it up to a lot of different disciplines, and it ended up in this one class I had 5 serologists, a couple of detectives, a couple of patrol officers, a couple of civilian crime scene techs, and a defense attorney. And after that class, I said that ended up being the best class that I've ever hosted because it was such a good opportunity for information sharing. Mm-hmm. And I just went to our departmental chair yesterday and said the same thing to him. And I said, I always talk about how well that class went. I thought, why don't I intentionally offer a class like that? And just say, take applications and intentionally place these different folks in, a forensic academy or a crime scene class, because I think that is the barrier, is that the communication just isn't there.
Great. Thank you, everyone. This has been a great panel, and I think we just have a couple of closing words from Ben.
I will keep them very brief. But to all of our panelists, as the editor-in-chief of the Law Review, I would be remiss to not mention that we would be ecstatic to work with you on any forthcoming publications, of course, that arise out of this symposium. And this has been a great opportunity for us as students to tackle a lot of these issues that many of us, and especially the Innocence Project, are, many of the issues they're presently working on. So this has been of great value to us, and I hope that it has been of great value to you as well, as an opportunity to kind of come together as a forensic and scientific group, and as a group who works on wrongful convictions and innocence. So I again thank you from the bottom of my heart for coming to West Virginia University College of Law. It has been our pleasure. And if you haven't signed up for a dinner, let us know, and we'll find a place for you to grab a bite to eat tonight. And I hope everyone else enjoyed this wonderful day. Thank you.